It's okay. I got thick skin. I'm sorry, Lita. All right, now, where are we, Mr. Pantera, on this case?
Right away, this courtroom has that chaotic energy where you can already tell things are not running smoothly behind the scenes. Judge Simpson starts lighthearted for a split second, but underneath that calm tone, he's already trying to figure out one critical issue. Who exactly is legally responsible here? And trust me, in landlord-tenant court, that question changes everything. Because this case is not just about unpaid rent anymore, it's about representation, authority, and whether the people standing in court are even allowed to speak for the business involved. You can already sense confusion between the property owner, the corporation, and the management company, and judges absolutely hate when parties walk into court unprepared on something this basic. Meanwhile, the tenant is sitting there, caught in the middle of a legal mess that feels way bigger than just a late payment dispute. And if this starts unraveling over technical legal issues instead of the actual rent disagreement, this entire hearing could go sideways fast. So the big question becomes, are these landlords actually prepared for court, or are they about to sink their own case before it even gets started?
This is not mine.
This is not yours. Whose is it?
This is the matter where they've been instructed to get counsel, Your Honor. And they
Where
have to get
Hannah Realty's been instructed to get counsel?
correct. Mr. Joseph Courtroom, I believe, is
Is
the
he
owner
Yes,
of.
Joseph is here.
Yeah.
Mr. Karam?
I'm the property owner.
Yes, sir.
Yes, sir.
But this is in the. It's a corporation that owns this property, right?
No, the corporation is my property owner acting on my behalf. I am the property owner.
And your name is correct. I don't have this filed as that. I have this filed under the name of the property of Hannah Realty and Property Management.
Yes, because they represent me. Michael, yeah.
But the lease is between who and who?
Between Hannah Property Realty and Lita.
So my understanding is Judge Washington has instructed that you are to have an attorney represent the plaintiff in this case.
I thought she said we should reach an agreement and bring it to her.
Well, certainly that can happen, but if you are going to appear for another hearing, it's very clear to me that you guys were instructed to get an attorney.
When we said we didn't have an attorney, she put us in a different room and said we should go and discuss it and come with an agreement.
Certainly. Do you have an agreement?
Yes, we do.
Ms. Boone, is that correct?
Yes.
This is the moment where Judge Simpson is desperately trying to salvage the situation before it turns into a full procedural disaster. And honestly, judges love settlements because settlements save time, reduce conflict, and avoid dragging everybody through a messy legal process. But notice what's happening here. Everybody keeps saying, we have an agreement, yet nobody sounds fully confident about what the agreement actually is. That is a massive red flag in court. If both sides truly understand and accept a deal, the explanation is usually clean, direct, and consistent. Instead, what we're getting is hesitation, interruptions, confusion about figures, and arguments over who can even legally read the agreement into the record. That's dangerous territory because once confusion enters a settlement discussion, judges immediately start worrying about coercion, misunderstanding, or unfair pressure. And now the tenant is facing financial obligations while simultaneously trying to process legal language in real time. You can already feel the tension building toward a bigger problem. Was this agreement genuinely voluntary, or was somebody cornered into accepting terms they didn't fully understand? Let me ask you this. Would you sign an agreement in court if you felt exhausted, overwhelmed, and outmatched?
All right. What is the agreement?
Michael, would you please read it out?
Well, okay. That's the property.
Well, I
manager.
can read it out. I can read it out.
Yeah, well, you'll have to because the property manager can't legally represent this
Okay,
corporation.
That's who wrote the contract
Wrote what contract, ma'am?
that he's going to read out to us. The agreement.
Okay. What is the agreement?
That the agreement is that I don't owe the 9, I owe 7,000. I think, and I don't have it right in front of me. And
I can
that
give you the figures. As at October 1st, she owed $7,449.58. The agreement was that she would start paying $500 a month, and she has already started making the payments, $500 a month. And then from November 1, she will make her regular monthly payments in addition to paying the back rent of $500 a month until it is paid off.
Okay, what day is the 500 due?
She has already paid the first one.
Okay, but the subsequent month, what day is she supposed to pay the 500?
It's on the first of each month.
So she's got to pay her rent and 500 on the first of each month?
Yes, please.
The only way I'm signing it is the 500 has got to be due by the 15th. If it's going to happen, there's no way somebody's going to be able to do that. Otherwise, she wouldn't be here.
and also in the contract, you stated, ask me how much I'll be able to pay. We never set a date. And today, now you saying I need to have the 18 and the 500. That's not in the contract that you sent me. So I'm confused right now.
And there it is, the exact moment this agreement starts falling apart in front of the judge. Miss Boone is no longer just quietly accepting terms. Now she's openly signaling confusion and possible disagreement. That matters enormously. Courts take settlement agreements seriously, but only if both parties clearly understand and voluntarily accept the terms. The second somebody says, "That's not what I agreed to," alarms start going off in a judge's mind. And honestly, you can understand why she's frustrated here. She's being told she owes regular rent plus an extra $500 payment every month, but she's saying the timing requirement was never fully established before today. That may sound small, but payment deadlines are everything in eviction and debt disputes, because one missed date can trigger another legal action immediately. Meanwhile, the property side keeps adjusting and clarifying terms in real time, which makes the entire agreement sound unstable. Judge Simpson is now watching a so-called settlement transform into active disagreement right in front of him. And the more emotional this becomes, the more likely the judge is to stop trusting that either side truly reached a fair meeting of the minds. This courtroom just shifted from negotiation mode into credibility evaluation mode.
Okay, I'm not sure what contract we're talking about.
We will agree to the 15th, Your Honor, the 500 by the 15th. So let's put that on record. In addition to the normal rent, which is due on the first of each month.
Miss,
I don't.
Miss Boone, is that what you agreed to? What?
Well,
Tell
we
me-
went into a Zoom room. I thought everything was unfair, but they said that this is the way it is. So I don't have no more fight in me. So
All right, hold on. So Miss Boone,
yes,
just tell me this. So you don't want to agree to this?
I don't want to be.
Okay, go ahead. What were you going to say? I'm sorry, I didn't mean to interrupt you.
I'm just agreeing to it.
Well, hold on. Talk to me, okay? I wouldn't ask if I didn't care.
It's just give me a second. So in the Zoom room, we had made a meeting. His property management told him that it was things in here that I spent a lot of money on paying to fix up this place. Well, first of all, I moved in unaware that it was infested with bugs. So I took care of that problem. So he did pay me back for that. And then I noticed like 2 weeks later, I had moved a barbecue grill and it was a big hole in the patio. So I paid like $1,500 to fix that. The washer and dryer and stove and refrigerator that came with the house was all didn't work. So I had to fix it. So that made me get behind in the bills. And then he just came and fixed the electricity and my bill was going up. It was $600 every month and I'm by myself.
Now, the case takes a completely different emotional turn because Miss Boone isn't just talking about unpaid rent anymore. She's explaining why she fell behind in the first place. And honestly, this is where viewers start seeing the human side of landlord-tenant court that statistics never capture. She's describing bug infestations, damaged property, broken appliances, utility issues, and massive electric bills that allegedly dropped dramatically after repairs were finally made. If those claims are accurate, that changes the emotional weight of the situation entirely. Suddenly, this isn't just tenant owes money, it becomes a story about someone feeling financially buried while trying to maintain basic living conditions. And notice something important here. Judge Simpson is listening carefully. He's not interrupting aggressively because judges need to understand whether unpaid rent came from irresponsibility or from a property dispute that spiraled out of control. At the same time, landlords also have rights, and courts still expect rent obligations to be met unless specific legal procedures are followed. That's why these cases become so explosive. Both sides feel justified, both sides feel unheard, and eventually everything collapses into courtroom conflict. Have you ever noticed how the truth in these cases usually sits somewhere between both stories?
And I'm like telling him that it's a problem with electricity. And he just came and fixed it 2 weeks ago. And you can notice my bill went back down to 150 instead of 600 a month. So I've been paying him every 2 weeks that I can and stuff. And then one check he said he never got, but I just been paying him trying to catch up. And I couldn't never catch up. So I told him, let's go to court and get this settled because I'm constantly giving you guys all my money and it's looking like I'm never catching up and I don't know what's going on.
So what it sounds like to me is there was not an agreement when you guys came out of that Zoom room.
The agreement was that he would take off because he said I owe $9,000. So he took off the Orchid bill and
the Orkin bill.
Yes.
Is that the pest bill?
Yes.
Why are you paying that anyway?
Because he said his property manager said that I didn't report to him that it had a bug problem. And then when I talked to Orchid, they said it was already a bug problem here. So I just paid for it. I didn't know I work a lot. So I just want to live nice and comfortably. But for $1,800 a month.
I hear you. But, well, that wasn't going to be on there anyway. Or shouldn't have been on there because that's typically it's going to be the landlord's responsibility.
He said since I didn't inform him with these problems, which I did. So
okay. All right. I'm going to stop this right now. Sir, my understanding is Judge Washington told you guys to get an attorney.
We told him we will try and get
Did Judge Washington tell you, sir, don't play a word game with me. Did she inform you to get an attorney?
Yes, but then she said
hold on, and you showed up today without an attorney.
Sir, if I can answer, may I answer, please? She put us, when we said we didn't have an attorney, she put us in a Zoom room and said, go and get this settled and come back.
This is the exact section where the landlords are trying to explain why they showed up without legal counsel. But the deeper they explain it, the worse the situation actually becomes. Judge Simpson is laser-focused on one issue now. The corporation needed an attorney, and despite prior warnings, no attorney appeared. That is not a tiny technicality. In many jurisdictions, corporations legally cannot represent themselves in court through non-lawyers because a corporation is considered a separate legal entity. So even if the owner feels personally involved, the court still requires licensed counsel. And you can hear the frustration building from the judge because he believes the previous warning was crystal clear. Meanwhile, the property side keeps emphasizing the Zoom room negotiations as proof they acted in good faith. But good faith does not override procedural law. That's the trap they walked into here. They thought reaching a settlement would smooth everything over, while Judge Simpson is thinking, you ignored a direct legal instruction. Those are two completely different conversations happening at the same time. And once a judge believes parties are playing semantic games instead of following orders, patience disappears very quickly in a courtroom.
And when we did, we asked Lita, would she be able to afford an attorney? She said no. So we actually went through all this with her, and we thought we had an agreement. We signed the document.
You don't understand something. You have to have an attorney because it's a corporation that the lease is signed with. The lease is between a corporation and Miss Boone. The
Yes.
lease is between you and the corporation who filed this. However it got filed that way, has to have an attorney.
Yes, Your Honor. This
Yeah.
is Hannah Realty and Property Management, Michael Hanna. Yes, when we were in there, the judge advised that because I had put my name on there.
Then why are you guys here without an attorney?
Okay, well, can I finish, sir? Your Honor, she said, okay, she asked the tenant leader, did you seek out counsel? And she said yes, but she didn't qualify. So she would have to obtain her own attorney. So then the judge told both parties, look, y'all need to work this out. You need to come into some type of agreement. And she put us in the room. So we went in the room and we came up with agreement. I mean, we stayed there for hours. And what Ms. Boone is talking about, which I know is really kind of like irrelevant, the orchid, when she said, I said, we paid for the first remedy of these bugs. And I guess she reached back out to them and said they didn't do it right. And they told her something in which she had to pay more money and had her paying $300 a month or something on some type of contract with them. And I said, Lita, why come you didn't tell me about this? I said, why you didn't tell us so that we could deal with them? If you saying they didn't do it right, but you enter into a contract with them without our knowledge, that's not the owner's, responsibility.
At this point, the hearing completely loses structure and turns into overlapping accusations, interruptions, and emotional frustration. And honestly, this is exactly what judges try to prevent, because once parties start arguing directly with each other instead of addressing the court, the entire proceeding spirals into chaos. Notice what's happening here. Both sides are now battling over memory, communication, and responsibility. The landlord says he wasn't informed properly. The tenant insists she absolutely did notify them. And now we're stuck in one of the most common courtroom deadlocks imaginable, two completely different versions of the same events. But then the situation gets even worse when personal financial details start getting dragged into open court. Judge Simpson immediately shuts that down because courts are not the place for humiliating somebody or weaponizing private struggles during an argument. That reaction from the judge is incredibly important. It shows he's no longer just evaluating unpaid rent, he's evaluating professionalism, conduct, and whether this case has become fundamentally improper from a legal standpoint. The emotional temperature in this courtroom is now boiling over, and you can feel Judge Simpson getting ready to make a decisive move.
So that's what we
Mike,
got
you
to
told me, Mike,
well, we came up with the
that
number.
morning, I'm sorry to interrupt you, but the morning that I woke up and it was infested, I told you, look on my other phone number, I told you. You told me to call Orkin, but now you don't remember.
But we paid for that. We paid for that.
But you just told the judge that I didn't give you no knowledge of what was going
Not
on.
on the second
That's
time.
what I'm
No,
saying.
the
You're
second
confusing
time.
me.
No, wait a minute. Don't be confused because you the one told me. I didn't know nothing about it. We was wondering why was you paying $300 a month? You told me you paying all this money. I understand your daughter got in problems. You was getting garnishes. But what I'm saying is about
I don't
this
have any
about,
garnishes,
Stop
sir.
right
I don't
now.
have no
about the
garnishes.
orchid, about the orchid thing.
Stop.
That's what
Stop. What part of stop don't you understand? I'm not having it. You guys are supposed to show up with an attorney. You don't have an attorney of rights. This case ought to be dismissed because you can't represent the corporation. That's what the judge told you before. And I'm not going to have you going around and around with Miss Boone and trying to throw her business out in the street and say she's got this and that. Not going to happen here. Not today. Judge Washington gave you the warning. I understand it, that you were supposed to be represented by counsel. She may have put you into a room so that you guys could agree to it. My understanding in listening to Miss Boone is that she has not agreed to something, or at least feels that she's coerced in doing so. You guys don't have an attorney. You keep trying to represent yourself. If you want to go ahead and commit a felony, because it's a 4-year felony for you to be representing a corporation, if you want to do that, you go ahead. You're not going to do that on my watch. Case dismissed. You can start over. Thank you.
And just like that, the entire case collapses. Judge Simpson dismisses it completely, not because the rent dispute magically disappeared, but because the procedural problems became impossible to ignore. The court repeatedly warned the property side that a corporation must be represented by an attorney, yet they still appeared without proper counsel and continued attempting to speak on behalf of the company. For Judge Simpson, that crossed the line. But what makes this hearing so fascinating is how many layers were unfolding underneath that legal issue. You had confusion over settlement terms, arguments about repairs and infestations, disputes over communication, rising emotional pressure, and a tenant who clearly felt overwhelmed and financially trapped. By the end, the judge wasn't convinced there was a clean, voluntary agreement at all. Instead, he saw a hearing drifting deeper into disorder and potential legal violations. So rather than forcing a flawed resolution, he shut the entire thing down and told them to start over properly. That ruling may feel dramatic, but from the court's perspective, procedure matters just as much as the facts themselves. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.